Bills this September 23rd, 2019. And the first item on the agenda is to approve the minutes of April 25th, 2019. Are there any, do I have a motion?
I'll move that we accept.
I'll second that motion.
Any discussion? I have one that on page 4, at the end of item 5, the last paragraph, it says the request for variance was denied by a 2-4 vote. And it's probably a nit, but normally you have the higher number first. You should be denied by 4-2 vote rather than 2-2. So I would like to make a motion that we add that modification to the,
Okay, so seconded.
and
Mr. Chairman, where was that again?
that's on page 4, right in the middle of the page, right before item 6, the last paragraph of item 5.
I see.
Okay, so we have a motion and a second to modify the agenda, or the minutes. Now we can vote on that modification. All in favor of the modification, raise your right hand.
Aye.
Okay, motion carried. Now we're back to voting on the minutes. So do we, since that was opened and second already, do we just have a vote, or do we have to?
Move the question.
Okay. And do we need a second to move the question?
I don't want to just parachute in and start giving rules of procedure. My name's David Root. I'm the county attorney. I've met some of you all before. But yeah, you've had a motion and a second. You amended that main motion, so now the motion, you just have to vote or have further discussion or additional amendment
Okay.
on the main motion.
Okay, any further discussion on the minutes? Okay, all in favor of the minutes as modified, raise your right hand. Motion carried. Okay, so the next item on the agenda is public comment, and I don't see anybody here for public comment. So I guess we'll pass on that one. And then item 4 is staff update and discussion, BZA legal and policy issues. County attorney.
Thank you, sir. And let me thank all you all for your service. I know it's a thankless task oftentimes, and the BZA can be a controversial venue. So I know, speaking on behalf, I'll take that liberty, of everyone within county staff and council is appreciated what you all do, because it's a difficult task. And I avoid coming to these meetings not because of that, not because it's controversial, but because of some of the conflict issues that can arise, because I will have to defend the county from a decision that you all made if it gets appealed to the circuit court. That's why I generally don't get here, or come to these meetings. Plus, I often would tend to make it more convoluted, and that's been the case historically. Glad to come anytime you all need, though, so bear that in mind. The reason that I came tonight was Bill had a question about site visits, and I just wanted to kind of do a reminder about a couple other issues as well, but the primary issue that he wanted to speak on was site visits, and I think this was an issue that was dear to at least a couple of y'all's hearts. Wanted to get some guidance on. Bill gathered up some guidance from folks, his cohorts, planners, city administrators, to see what their practice was. There's not a uniform practice within the state. Some don't encourage it, but know that it often goes on just individually. So folks will, board members will know that there is a hearing going on a particular parcel. They'll do a drive-by, and that's not discouraged or encouraged. Some jurisdictions will encourage individual members to go do that, take a look, kind of walk the track, so to speak, so you know what you're dealing with. So long as you don't have a quorum present, because once you have a quorum present, you really need to have advertised that as a meeting beforehand. Your 24 hours, what you're going to do there, and follow all the rules and procedures that you follow just as if you're here. So those jurisdictions say, hey, yeah, it would be great for you all to go out and look at it, but do it individually. Make sure you don't have a quorum of the board when you go out there.
When you say quorum, for us it'd be 4, or no?
Yeah.
Yeah, 4.
So,
to me, I would question whether it's right for any two of us to go. To me, that, any discussions, unless we just go and we don't talk to each other, you know. But that seems like, ex parte is the right term for that particular interaction, but that seems like erroneous visit, as opposed to doing it individually and getting an idea of what the lay of the land is.
And that brings up the point, and kind of this path I'm going to go down is a really good point. Seabrook is the only jurisdiction that Bill came up with that does what I think is the best practice if you're going to do it. You don't have to follow my advice. Seabrook's practice is they do site visits as a formal procedure for all of the matters that come before them, for variance, for special exception, for administrative appeals. They notice it like a public meeting. They come here, come to their equivalent of here, take a recess, go out to the site, they record their visit at the site, an audible recording. They don't discuss what they see, but they see it as a group. The public knows that they're there. The public then obviously can go out there and do it. Then they come, I think the way I took the email was they would probably come back and adjourn and have the actual substantive hearing on that parcel on their next meeting. It could be done a number of different ways, but then they note, the chairman notes, hey, we had a site visit, it was noticed previously, we met, we essentially had the meeting at the site, a meeting at the site, we didn't discuss the matter, we all took a look at the property, surrounding properties, gathered that information, now we're going to come back here and we're going to have our hearing on the matter. I think that if you're going to have site visits is a good workable solution. When Bill first brought this up to me, and this is what I want to underscore, kind of my theme, and I don't want to go on a monologue, but my theme is you all are different than the Planning Commission in most instances in which it sits, different than any other committee or commission or board, because you're judicial in nature. You're quasi-judicial, but quasi diminishes the importance and the nature of what you're doing. You're really judicial in nature. So ex parte communications, how evidence is gathered, received, what you do with that evidence is very important, because the folks who come here with an issue that they need decided, the folks who are impacted by that decision need to ensure, we need to ensure, they want to have ensured, that they are afforded due process, equal protection, and that essentially that you treat everybody similarly, fairly, and that they have all of their rights protected through the process, because you all sit like a judge does. After you make your decision, that finding, if someone is dissatisfied with it, is appealed to the circuit court, just as if the circuit court made a decision and then someone appeals it to the Court of Appeals. So, but even more so, y'all's decision, unless there's something something stands out as being a discriminatory practice or something to set it aside, really, the judge will defer to your findings of fact, like a jury's findings. So your decision carries a lot of weight. The judge can't do a whole lot with it unless you're guided by an error of law, something of that nature. So all that is to say, I want to underscore that importance that y'all are sitting as judges. So when you make a decision and you hear and take evidence, you need to make sure that you do it in the most fair way possible. And so all that said, going back to your point, Mr. Codner, anytime that you drive by a parcel that's subject to a hearing, you're taking evidence, even if it's one person, but I think more so, to your point, when it's two people, you're discussing, you're starting that deliberative process, and hey, look at this, how does this impact on the property next door, and you're doing the work that most folks would say you should just do here. So that it's a dangerous line to go down, because is that fair? Do you do it for everybody the same way? But even if you did, is it fair for the folks who come in here to present their case that you already have a certain little pile of information, of evidence, that you have possession of, and maybe two of you have possession of it, and not, for purposes of tonight, not all five. So those two folks, when you go to your deliberations, may carry extra weight in that deliberation. Say, I've been to the site, and this is what I saw, and this is how it plays out. And that's not evidence that all the board members were able to gather at the same time. That's why I like, if you're gonna do it, the notion of doing it together as a site visit, formal site visit by essentially a meeting. Does that make sense? I'm sorry.
So, Mr. Root, if chances are whoever is requesting the appeal would be there, because they would want to be there, so that would be, they're going to want to talk to people, and they're going to want to talk to other people that are there. It seems like that could be kind of contentious and kind of a difficult situation.
It could, and there's no great workaround except for what the South Carolina Association of Counties puts out there as their opinion in this. I think Bill got all this to you all, that do not take any evidence, do not do site visits, do not talk to anybody. Just gather the evidence that you get during a hearing here. And so they would say don't do site visits. And because of reasons like that, it makes sense. What you can do, if you want to do site visits and you're going to do them as a group, you just have to make the rules of the road very clear. We're going out to do this. You all start talking, you start making arguments, you start having discussions about this, then we're going to cut it off, we're going to go home. And you're going to waste taxpayers' dollars, you're going to waste our time, but we're not going to have something that's going to cause a frailty in the whole proceedings to happen during a site visit. We're trying to get the most information we can to make a well-informed decision, et cetera. But yeah, you run that risk of something going wrong by virtue of having that. But again, something can go wrong by virtue of just having one person or two people go out there. You're going to have a risk of that. The safest route is what the Association of Counties says. Their attorney says, just take evidence here, period. Don't do site visits.
I have a concern with that. I mean, I think you need to gather evidence apart from the meeting. If you sit here in the meeting, you're going to get one slanted version of it from the person who wants the variance or the exception. And if you don't go out to the site and see it and take some evidence like photographs and things like that, you're going to be at a real disadvantage, and the board's going to be at a real disadvantage in terms of making a value judgment on that particular piece of property. And in all fairness, it may be detrimental to the person asking for the variance or the exception.
And that's a good point. It's a fair point, but that goes back to the judicial nature of the proceedings. If a judge, if I and Bill say he's an opposing attorney, and we walk into the courtroom, we're trying a case, and I happen to have done my work better than Bill did. I got all the witnesses I needed. I gathered all the demonstrative evidence that I needed, and I presented it to the judge, and Bill just didn't do his work. And his client picked a bad attorney, and I'm just picking on Bill. So Bill does not present the case well for his client. That judge may be better served in doing some investigation on behalf of Bill's client, but he cannot. That's just simply the matter. The fact of the matter is, the judge was given that evidence. The judge does not go out and search for evidence. The judge was given that evidence to him, and you're sitting in a similar nature. So I know you're objecting. You don't like this.
No, go ahead.
But that is the nature of the seat that you sit in when you're having these hearings.
The thought that I have, I'm the new member on the board, okay, so I'm probably the least experienced of, I am the least experienced of all. However, I have gone through the orientation, and that was one of the questions I brought up to the people giving us the orientation. They felt it was beneficial to go out and also to take pictures.
The picture taking, I would really object to more, because then you're manufacturing evidence. You would not think of what it is.
I'm not manufacturing, I'm taking evidence.
But I don't mean that manufacturing with a negative connotation.
No.
You're producing evidence. You have evidence being the picture, not the site itself. The site is, you see that's evidence, obviously, but you can take a picture and you bring it back, that is your evidence. So just like a judge bringing evidence into the courtroom, that's why I'm saying that's problematic for me. And I think a lot of attorneys would see it that way, but attorneys thankfully do not run the world, because things would not get done, often very quickly or very efficiently. But there are safeguards that we put in place, and I want to have put in place. And so that's the reason for no picture taking, things like this. But I understand how helpful it can be to go to the site. And that's what I'm saying. If you were my inclination would be to do it as a formal process so everyone sees what everybody else is seeing.
Yeah, John, I was with you before on that issue of
Yeah.
pictures, but I hear what our attorney is saying, is that really presents your point of view. You can slant the pictures perhaps, as to your point of view, and you're bringing that in to us as fact. Really, look, this is what I saw, and if we didn't all go
Yeah.
and see it, it could unduly slant us in the wrong direction. So I understand what the attorney's saying there.
Yeah.
I think, can we express opinions now?
Sure.
I don't,
I think we're just doing.
I want a chance to say
this
something.
formally.
We're just, I think it's imperative that we visit the site. I just, you look at what, for variance, we're supposed to, extraordinary and exceptional conditions pertaining to that particular piece of property. I've never been in that area. I don't know how, the kind of evidence we hear just doesn't lend itself to deciding that. Conditions do not generally apply to other property in the vicinity, and the variance will not be a substantial detriment to adjacent property of the public good. I mean, you gotta see the property, the individual situation there to tell what's going on.
Let me ask this, just throw something out there. So suppose that the full commission's here and, or whole committee's here, planning commission's here, whoever we are. Anyway, suppose that two go and visit, and nobody else does. And when the presentations are made, however way we find, whoever loses in that decision, would they have the right to say, well, you had two that influenced more than others because they went to the site? Would that judicially, could they file an appeal based on that, saying you had, like you said, 4 didn't go, 3 went, whatever, and therefore you've got either 2 or 3 or that went, that those of us that didn't go, we would sit there and say, well, I guess I'm going to go with what they say because they went and took a look at it. And would that judicially be where somebody could file an appeal and say, we didn't get a fair hearing because, these 2 or 3, whatever, kind of carried it? Would that be possible, or would that probably not go to appeal?
No, I think absolutely it would be possible. But you always got to remember, just like a lawsuit, you can get sued for anything.
Right.
Good reason, no reason, bad reason. So if I were an attorney just trying to think about the merits of the case, if that was it, if I just knew that my client suffered a negative decision and the only thing, it really didn't fit the variance criteria or the special exception criteria, so it was a loser. But I know that 2 members went out to the site, the other members didn't. I probably would not appeal on that because I think it'd be a waste of money. But if it was a close call, and if I saw during the process that those 2 members were having extra weight, had more to say, and that were perhaps swaying the hearing, and absolutely, I would, in that case, I would use that as a leadoff argument, because you're looking, when you appeal, you're looking, all right, was the decision that the board made guided by some discriminatory motive, guided by some lack of fairness to the parties, and that's it. But as a sole criteria, when it's otherwise, like I said, a loser, no, but it's something that you would include, even if it's a loser, as an extra argument. But if it was something that was, hey, this is the reason, I could say a fundamental reason why the board may have come to that decision, I would absolutely use that as a basis for an appeal. Because remember, the facts are not necessarily what the judge is going to be reviewing. It's going to be looking at how they apply those facts. And so you're going to be applying those facts based on 2 members having gotten extra evidence that wasn't done during the hearing.
Well, what's always scared me, we mentioned it a little bit ago before, is when you go out to a site, if you get out of the car and you walk and look, surely somebody's probably going to come over and ask and talk to you. So to me, right there, you've got a problem. Because you've got somebody that is already talking on whichever side, either for or against, but they're having one-on-one conversation, or if a couple's out there, whatever, but they're having one-on-one conversation without the full body being present and without it being brought here. That's one of the reasons that when I used to go to a lot of the sites, and then I decided I just didn't want to, because of the fact I didn't want somebody to say, well, when I talked to you up there, you were all for it, and now you're voting no. What's this all about?
You don't know if someone's gonna quote you correctly, it's just a matter that it happened, and that's something to always be guided by in this, or any other issues. Is there an appearance of impropriety? Whether or not you have the best motives, whether or not you're even there for this. This particular site that's subject to this hearing a month from now, my friend lives next door, two doors down, and we're taking a stroll around, we just happened to pause there. I wouldn't take that route. I would go a different way, because that appearance of impropriety. But I'm gonna be more conservative than perhaps is necessary in that. But to your point, what SCAC, or Association of Counties, says, when conducting a judicial or quasi-judicial hearing, the board commission members take on the role of impartial triers of fact. Obviously, you're resolving the legal rights of one or more parties. You need to be careful to provide the basic legal rights under state and federal constitutions, mainly speaking equal protection due process rights. And the members should base their decisions solely on the evidence presented at the hearing. Members should not discuss the case beforehand or be influenced by the opinions of others who are not part of the proceedings. That's SCAC's attorney's opinion who wrote this. Like I said, that's not codified in the state statute, but it's because of the dangers that are inherent that could come up, which would be a potential reason for overturning your decision, which is what we don't want to have, or a potential thing that would bootstrap me, hamstring me, or whatever if I try to defend it, is because there was some activity that went on the site that wasn't proper or didn't look proper. So,
Could a happy medium be that staff takes more pictures and that
I was
staff,
just,
makes that available to us?
I was gonna say, could they go out and impartially take pictures for us?
and the staff is it's an oddity, and this is why it's quasi, because it gets outside of the normal thing. Staff's like the bailiff or the court reporter. Yes, they can, because they weigh in on the proceedings, particularly obviously if it's an appeal from one of their decisions, but even a special exception and variance, they would submit a report to you all, correct? That's still the practice. And within that practice, there should be, a variety of pictures and evidence that they bring in. They're supposed to be, in this variance special exception thing, also impartial. All of us here attempting to serve the appellant or the constituent who's bringing an appeal, but also anyone who's opposed to it. So yes, I think if that's a happy medium or however it falls, yes, I believe a wealth of good photographs, whatever, can be helpful.
In stare decisis, is there a case where this has been an issue?
I didn't find any, and I will say
Well, it's
that.
really a non-issue, isn't it?
No, it's that when you got to look into. I didn't find a case that was particularly on point that said, "Hey, we overturned the Board of Zoning Appeals decision because two members or one member went out and did a site visit." You got to work by analogy. So what we're dealing with is the analogies. Is this was some activity taken that denied somebody their due process? And so that obviously there's thousands upon thousands of cases that deal with equal protection and due process cases, but I didn't find one that was exactly on point with this particular issue. Is it an issue? Yes, the issue is we're talking about it. We want to make sure you do it right, but because I would rather have Oconee County not be that first case.
What if we were to put on the application the fact that the board either individually or collectively may go on to that particular property and look at it for purposes of understanding the situation and have the person sign that? Would that resolve some of your issues?
Like in the sense that might be kind of a waiver of any complaint that you might
Right,
have about the process.
giving us permission to, explicitly giving us permission to go on and to look at their property as part of the application process.
One, you'd want that permission before you traipse onto the property, as opposed to being on the curtilage or the curvage or whatever. But it wouldn't operate to get rid of the other problems that we've spoken of, because you got to think, say it's a very hot button issue. You've got the one person who's the applicant for variance, and then you've got a room full of folks who are opposed to it, or maybe some who are in favor of it. the case law has been recently fine-tuned, is probably most of these folks out here in the audience could appeal it. So they're interested parties. Obviously, they need to have some more interest than just me appealing something in Salem because I live near Seneca. But, so it needs to be near their property, have some impact. This decision has some impact on property, their property values, their traffic, whatever. But that would give them standing to appeal it. So they're not signing off on this process. So they would have a complaint. If you rule in favor of the applicant, you said, yeah, I'm good with the site visit, they may still have that objection. And so and this is why I came to this kind of, because knowing that you may want to do this, is thinking this is the best resolution is, it happens sometimes, but not frequently, but courts with the jury will say, hey, a foreman, jury judge, we can't make a decision, or during the proceedings, we just can't figure out this intersection or figure out this inside the home, how it's configured. We want to go out and look and take a field trip. Judge will do that. Within his discretion, he will do that. And the attorneys can argue, make a motion, whatever, and say, don't do this, or yes, do this. But that's within the province discretion of the judge to do. And so that's that kind of formal process. Not one juror goes out there on his or her own, but they go out there as a group with the judge kind of obviously orchestrating everything to make sure they all have the same, gather essentially the same information.
Go ahead if you want to finish. I guess one thing I come around is our whole mission here ought to be to do what is, quote, right. We ought to get as much data as we can and do what's right for the parties involved, and not get all bound up by some concerns about what might happen if someone gets a problem, has a problem with what was decided. Sounds like that's not very common. We've never been sued that I know of. Has the county ever been sued for a BZA decision?
Yeah, we have about 3 years ago.
Okay.
It wasn't based on a site visit. I will tell
Say
you that.
that?
I said it wasn't based on a site visit. I will tell you that. It was just based on someone who objected to the decision, and they had an attorney who had the funds to do it. But I agree with you. It's based on doing what's right, but these legal paradigms are put in place to give you guidance on how to do what's right.
But I can think of at least two, or not, if not three, I would have been on a year, and two or three that I probably would have voted reverse of what I did if I hadn't seen the property. Because I had no idea what it looked like, what idea the situation was. I think it's imperative that you visit the properties. Whether we do it individually or alone, I think it's just imperative that you visit. And like if you're doing it alone and someone comes out and asks you what's going on, you just don't talk, you just say nothing. Hey, I can't talk to you, I'm sorry. You have no interaction. I understand it can cause some appearance of impropriety, and I agree with that concept. I was raised that way, and I agree, you don't want the appearance of impropriety, but you gotta kind of find some way here to get the information you need in a reasonable way that we can all agree is reasonable. And again, I think it is. Well, I think the most ethical way to proceed is for everyone to see the site, at least be familiar with it. If it's 2 blocks down from where you live, then you already know what it is. You don't need to make a special trip to visit. Or if you're just familiar with the area it's in, and you say, yeah, I know where that is, and I can decide on that, that's fine. It's another thing, if you've never been there and you have no idea what it looks like, then you ought to make it a point to go see it. And
If staff had given us more detailed pictures, would that have alleviated the need to visit the site sometime? No?
some pictures, there was one case where we had pictures of a guy wanted to move a trailer, and that helped. Those pictures helped some if we'd had them, but in general, I don't think pictures are that big a deal. If you've been to see it, you got your own mind, you can see the whole thing.
That bothers me because you're making a decision about something before you ever hear the evidence.
What are you deciding?
Well, you said you made up your mind.
Oh, no.
You're making up your mind before you hear the evidence.
No, that's not true.
Our job is to listen to what's presented to us and make a decision based on what is presented to us.
You misunderstood what I said. I wouldn't have decided the way I did if I hadn't had a site visit to then listen to the evidence presented. I didn't decide out there what I was going to do. Because I remember we talked about these particular ones a lot, and went back and forth, and we finally decided what we were gonna do. But I have no intention of going to a site and making up my mind what's right or wrong. That's not the idea.
Is it up to the BZA to decide the process for this, or are we just gathering information for somebody else to make that?
No, it really is up to you all. Staff obviously
Our
gives you
call.
guidance, I'm giving you guidance. But in as much as it's within kind of my bailiwick, I would very much encourage staff, with whatever weight I could encourage them, not to say, hey, guys, go out and look at the site individually. I would say that would be problematic for them to encourage you to take. If you want to, go take site visits. I would have a problem with that. If you all decided to or not to do on your own, then that's just the way it is. If you decide to formalize the process, wouldn't go with the, hey, I encourage y'all to take a look at it if you want to individually. I would do the either everyone or a process similar to what the circuit court does when you have situations that are just lend themselves to it. You can't make a decision, you're hearing the evidence, hey, have a motion process in place where any one of you all can say, Mr. Chairman, I move that we recess and do a site visit on X day, then we'll follow up and finish up the hearing. You would rule on it then, say yes or no, and then someone could appeal your ruling, essentially, within this. Like, so it'd play out this way. You can't make a decision, someone wants to do a site visit, so you let's move at it. Mr. Chairman, I move that we have a site visit a week from now before we finish this. I can't make a decision up. You'd make a decision at that point. If anyone wasn't satisfied with the decision, you'd appeal it and then y'all vote. That's just the way the rules are, how you'd get to it. I kind of like that process, just so long as you pretty much administered it fairly.
But you have to have a quorum present for that, right?
Yes, that would be during your primary hearing. And
But
then
for the field visit, do you have to have a quorum present?
well, yes, I would have it. Yeah, there's.
I mean, we
issues
have a
inherent.
problem
It's not
getting a
only
quorum present
quorum.
for a meeting.
Not only a quorum present, but one would argue that the same people were at the hearing where you made that motion to recess to it should also be the exact same people, no more, no less, than go to the site.
Well, I see that as a real problem.
Yeah, it's practical.
Procedurally, I just see that whole process as really getting caught up on our shorts over this whole issue.
I mean, we're making it too bureaucratic. When
Yeah,
you're making a problem when there really isn't a problem. You know, tell us how we can do something rather than why we can't do it.
I've told you how you can do it, and I'm not making a problem. I'm just told you, I think, not how you want to hear me say you can do it. But it really is. It's not a bureaucratic issue. It's a matter of fairness to the parties, and this is just.
But I take exception to that because I think it is being you're being more fair with the party when you understand what the situation is. If you have a site visit and you see what it is, then you understand what they're telling you when they come in here and ask for that exception or that variance. And you can see it, and you can visually see what they're telling you. And if they just come in and start talking from the podium, and you don't have the foggiest idea of what they're talking about, you know, you're probably gonna say, well, I think I'll vote against them.
You're going to make a judgment call based on the evidence produced before you, not on what you determined when you're in the field.
I would be making a judgment on an overall package of what I have seen and what he's telling me. Then I understand what he's telling me. Up until this point, if I haven't seen it, he could tell me almost anything, and I don't know what he's talking about.
And I'm not objecting to, I'm not saying that there's anything wrong with that, I agree with that, you want the whole,
I want the whole
to
picture.
get all the information you can,
And-
but if just you had, the issue, going back to the very beginning, if just you has that information, or just you and Mr. Codner has that information, and the other board members do not, then that creates the problems, the imbalances. Yes, it puts you in a better position to make an informed decision, but it puts you in a different position than the other board members, perhaps to the disadvantage of the applicant or the folks who may appeal afterwards. That's my point, why I like, if you're gonna do it as a group.
And Jim, I
I
know
don't have a
that,
problem with doing it as a group, but I just think it needs to be done.
But the issue of doing it in a group procedurally is, you gotta have a whole group go, whoever's gonna meet here has gotta go to that group meeting, and then come back and all be here for this meeting.
And I'm not retired, so I can't
You
just
can
drop
just-
everything.
and in all
he's not
fairness-
retired, and Charles Morgan's not retired.
I agree totally.
And in fairness,
That's why I think that's getting procedurally just too bound up.
we're
in
getting
our
wrapped
shoulders.
around the
We're just-
axle.
All right, so going back to the beginning, and I'll leave off with this. We had 3 sources. There was the planners that Bill talked to, and they were all over the board. Some didn't go, didn't encourage, don't know what the board members did, so maybe they showed up with information or not. Some said, yeah, go out and look at it. I'm opposed to that, but that's y'all's decision again. Seabrook or Kiowa, Seabrook, had the formal procedure. Let's go out, all go out there. It's a meeting. We'll all go out there every time and do it. So it's all on that continuum. County attorneys, threw the question out there to see what they did procedurally. There was no practice that was uniform among them. Some of them said, yeah, I know some of our folks go out there and look at it, and sometimes they do, sometimes they don't. Is it a problem? Don't know. Nobody said, hey, I've got war stories, and there's plenty of war stories that happen. All I can tell you is that from a due process perspective, it could present problems, and that's my job, that's my position to do that. And then the third point of authority would be the Association of County Attorneys, or excuse me, Association of Counties. Their position was just take the evidence at the hearing. So you have those 3, you got a swaths of authority.
Go ahead, are you
No,
still?
No, it's all right.
You know, a lot we're talking about is, you know, is there extra information to learn about the case by going to the site? I've gone on some site visits and but I don't have a single situation like Jim, you said you had, where if I had gone to the site, I would have made maybe a different decision than what I did. I would like to put more onus on staff to give us better information so we don't have to go to the site many times. There may be 1 or 2 cases, but I like the inference that maybe, rather than saying in our procedure that it's encouraged to visit the site, we just leave that silent. And if somebody wants to go on their own, that's been our practice for the last few years. That hasn't hurt us, so maybe we could continue that if somebody on their own wants to do it. But at least give more information to the total group so that it should alleviate the need for a site visit. That's where I'd like to see the emphasis personally.
Well, I have a problem with us giving evidence. We're here to rule on the evidence that's presented. So if you go to the field, you bring it back in your head, but you're not allowed to talk about it. I don't want to hear your opinion of what you saw out there. What they give us as evidence is all I want to hear. What you know is what you know and how you vote. But I don't want to hear your opinion unless it was spoke there. So if you want to make a field trip, that's fine. I just don't want to know your opinion of what you found. I don't want to see your pictures. I don't want to see your investigation. I don't want to see your evidence, because you are not the person presenting evidence. The person presenting evidence is out there. Does that make sense?
I hear what you're saying, but also, we need to be able to decide based on the overall picture out there.
No.
Yeah.
Then you're presenting evidence.
Gotta read this.
You're presenting evidence at that
Still
point.
agree.
No, you're gathering evidence.
Now, if you come in here with your mind already decided, or you come in here and you listen, but you've got something in your mind that you think is the truth that wasn't presented, then you're presenting evidence.
So what you're saying is that if somebody comes in
Your job
here-
is to sit here and judge the evidence that's presented to us, not to go find your evidence. You are to judge the evidence we are presented.
So you don't think we should verify anything? We should.
No, because they raised their
We-
hand and swear to it.
No, they haven't. Nobody's raised their hand and swore to anything.
This is a legal thing,
Yeah,
yes.
but nobody has done that. Nobody has sworn that they're telling the truth, the whole
Well,
truth.
they know they're
But the
recorded,
truth.
and they know it's going to be something that goes into court as evidence.
But
If this is appealed, what is presented here and is on tape is the evidence that is appealed.
But if somebody is coming before us and they have a particular thing that they're trying to accomplish, they're going to put that in the most favorable means that they possibly can.
Well, anybody that
Okay.
don't want it has the right to come
And if
in
you
and present
haven't-
their side.
But if you haven't, well, maybe other people for some reason haven't come.
So you're going to be for the opposition.
No, I'm just saying.
That's not your
what I'm
job.
saying-
Your job is to be
No,
the
That
judge.
isn't what I'm saying. I'm saying that maybe somebody else hasn't come But, so they haven't, we don't get any other evidence other than what that individual's telling us. And it could be very slanted, it could be very beneficial, it might even be dishonest.
Well,
And we have absolutely
if there's
no way.
nobody there in opposition to present the other side, you have to take the evidence that's presented to you.
I agree.
And I think just for, what I'm hearing from both sides is that if somebody wants to on their own go out there, but they're gathering only, their own
As long as it stays in your head and it's not vocalized,
And
I don't have a problem with
I
it.
think you're in agreement with that, right?
What,
That
with what?
if you went out to the site and you gathered information, that's helping you make an informed decision, but you're not going to be sharing that information that's unique, that you found out, to the rest of the group.
If that person that's presenting it gives something that's contrary to what I've seen, I would make note of that.
No, that's the problem then.
That's the problem.
I don't think.
Because at that point, you're presenting evidence, and that's not your job.
To Mr. Root, are we,
Y'all are right on the point. You got the problem, yeah.
so this is an exposure area, though, what we just said.
It is, and I think, and I'm sorry, I don't know your name, I didn't see you.
Oh, I'm Gwen Fowler.
Ms. Fowler, I mean, she brings up that point, and once you get to that point in the proceedings where you say, hey, that is not correct because I went to the site visit and what he's saying is inaccurate, then you are presenting evidence, you're becoming an advocate. And understand, I mean, settling a dispute amongst your kids or amongst whomever, that's the way you want to do it. But in this particular forum, as a quasi-judicial forum, in a hearing, that creates exposure for a decision that you make being overturned. And that's all I can say, the best way to say that.
Mr. Chairman, just for what it's worth, let me suggest, what staff could do from our end, and I think you alluded to it. And that is, we could provide a more complete photographic record of the site. We could do that. And we could probably do a more thorough job in filling in the blanks on the details of the site. For example, the topography of the site, even soil content if necessary, but things that go directly to the issues at hand, the character of the property, the shape, the things that some of that you see on the screens when we present, but probably we could do a good deal more in terms of filling in the detail that goes to the heart of what these issues are about. And I think that the photographic evidence is part of that, but, I think that's the angle we could take, and some shops do more than others in terms of the document, in terms of the evidence that the staff presents to them.
But what you present has to be unbiased.
Oh. Well, I'm just giving you my sense of what we could present to you.
Yeah, and I think yes, it does. And I think it seems like, my recollection, I haven't looked back at it, your report is presented to, if there's two parties or both sides, but at least certainly the applicant beforehand.
Yeah.
Correct? So they would have an opportunity to object to any photographs that they didn't actually depict the nature, or the proceedings. But I get what you're saying. I mean, it's sometimes not practical, and you want to make an informed decision. That's laudable, and it's a good thing. But I can just tell you that the problems that you're finding, that you stumble across, and I think you fleshed them out well. If you got into a hearing and you started arguing for the other side because you went to the site and y'all made a decision up and it got appealed, I would argue that was essentially a
Problem.
Yeah.
We understand
I'm
that.
arguing for the county.
You're not arguing.
Problematic, but it was something of no moment, that it didn't have any effect on the ultimate decision, unless it did. And if it did, then you shouldn't have gone there. I mean, that's the end run of it all.
I was thinking not giving evidence, however, it allows you to ask better questions.
No, that's fair. I mean, it's a good.
Is really, so from that standpoint, it does kind of come out, some of it comes out in the public meeting that you do have, because you're asking questions that might not have been asked before.
And in reality, that we're looking at particular kind of situation, but in the real world, I mean, if a Dollar General store or whatever is going to go on a major intersection, site visit policy or not, everybody's going to have a particular perspective, a particular disposition, or whatever. You all are going to carry that with you. You carry that luggage with you, and you're going to ask questions coming from that point of view, what you've seen on drive-bys or whatever, and that's not prohibited by law. But what you want to make sure that you do is still treat the applicant fairly.
Yeah.
As if you are, because you are supposed to be, a neutral. And that's what it all comes back to. You're not an advocate for one side or the other. Y'all are impartial, triers of fact, neutrals. You don't have any dog in the hunt. You just weigh that
We're here to
evidence
serve the public.
and then make a decision.
What I take away from the conversation is, some of us at least have a feel to go out and see the site in order to make our own best decision on what's right, based on what we see at the site and based on all the evidence given. That's kind of where I'm at. We should not use those observations as, quote, evidence in the discussion. But we could, it's certainly part of your overall decision. And that's where I come out saying, any one of us really ought to go out and be familiar with the site so that we can make our own decision on what is best when we discuss it here in the hearing, as opposed to just relying on whatever vagaries are presented by the for and against people. We ought to have an idea of what the site looks like, because all of it a lot of the issues depend on what is the effect on the rest of the properties around. What's the effect on the neighbors? What's the effect on the community? And if you don't have a sense of the neighborhood and the community, you can't reach a decision on your own decision on that, just based on whatever they happen to say. Because it's not, they don't have lawyers, and the lawyers aren't presenting a whole long list of pros and cons and making an argument like David would make. It's just hit or miss. And if I hadn't seen, when we were talking about out at Devil's Fork State Park, is that it? What we were hearing? You weren't here.
No.
We had those two special exception hearings. If I hadn't been aware of what that whole area looked like and kind of had my own feeling for what it was like, I would have voted differently than I did. And I just wouldn't have reached the right decision as far as I'm concerned. So I think it's incumbent on each one of us to go see the site, not come back and give evidence, not take one side or the other, but use that then in conjunction with the evidence given. A lot of the evidence we get ahead of time. We get all these letters and whatnot, we get the requests and the letters, and we get that. We're going to come in here with an idea of what's going on. And we can hear them reiterate what's in the letters and give their own opinions. But if we don't have that background of having seen the site, I don't know how we can make a reasonable decision.
So, Mr. Root, if we don't say anything in the procedure about site visits and just people do their own thing, we don't say it's a good thing, we don't say it's a bad thing, we're just quiet on the subject, but we just proceed as we have in the last, I don't know how many years we've been on the boards, and people have done site visits whenever they want to. And so if we have that practice, do we have to, is it okay just to be silent on the site visit?
It is. There would be no change necessary in your rules of procedure. And I would just bear in mind that just the notion of polluting the pool, your fellow triers of fact, based on what you've seen, is what you would need to be mindful of. But no, there would be no change, and it's not Oconee County the only one who would be doing it this way. It's a number of other counties just have this informal practice. Sometimes you go out to see the site, and sometimes you don't.
I guess I can see, if you cited Kiowa, and you cited another county or something.
Kiowa was the only municipality, was the only jurisdiction that we got the information from that had that formal
I think it's the
procedure.
only one in the state that does that.
So I can see a Kiowa doing that, okay? Or a Hilton Head, or one of those where they get all caught up in what you can and can't do. They got all kinds of rules and regulations, and I'm sure there's people who want all kinds of exceptions. So I can see why they would do that. Sleepy little Oconee County, I mean, we're just not the same.
Not the same. Becoming less sleepy though.
I got you. Don't get me started on that one.
And I think, I'm sorry, go ahead.
Would it be wise for us to put something in the application, though, that says that the applicant gives the right for either the staff or members of the board to view the site?
For my money, I would leave it alone.
You would?
As
I
it
don't
is.
think I do.
Yeah.
Okay.
I would leave it as
I
it
don't
is.
think, the ones we've done, I don't think there's been a need at all to trespass on the property, to go on the property, to have access to the property. When I've done visits, you can see everything you need to see from the road. If it's too far from the road, then I'm not sure what the issue is. You know, if you just can't see it at all, I don't,
That's a fair point, yeah.
Well, one exception would have been that one down on Peninsula, where those houses were close together.
yeah,
Yeah, and you couldn't see that from the road.
you know.
You had to
yeah,
go
that's
into
what-
the-
that's
had
what-
to
yeah,
go into
I
the
agree. That's
development
what-
to
but
see it.
It was, we handled that.
Yeah.
But as for communication to the board, just, if in fact we're quiet on this site visit thing, the thing that makes me feel a little more comfortable, that if we give more information, if staff gives us more information on the pictures and about the visits, I'm hoping that our need to do site visits will lessen, so there won't be a whole bunch of us going out there individually, because we'll feel that most of the information is presented to us. So that's, do we need to vote on that, or is that something you just are gonna do?
We're not gonna make a change.
No,
We
we're
think so.
just gonna continue as we had, I mean,
Right.
status quo.
No, we, just procedurally, we could just try to beef it up a little bit in terms of the photographic record.
But now, the photographic record will come from staff and not from
Oh, yeah.
members.
But won't you
correct?
need,
And also in terms of just the.
will you need permission to go on, will he need permission to go onto the site for the?
I mean, at
photograph?
times, as a zoning official, he has that
Yes,
inherent
right.
right to do that.
Do we have the right to also, is?
No, you get in trouble.
Nice try.
I'm not gonna give
Nice try.
Just checking.
No, it's a good conversation. It's important, and I'm glad y'all are taking it seriously. Obviously, not meaning to be patronizing, but it is. A lot of folks will get on in positions like this because they have a particular axe to grind, and they have a particular agenda or whatever. And you're taking seriously the fact that you want to gather information, render a fair decision. It's important. Obviously, if I were an applicant or an appellant, that's what I'd want. I would crave your reference, though, to the materials I handed or gave to Bill from the Municipal Association and the Association of Counties. It has some good information in there about ex parte communications, probably similar stuff that y'all had through your orientation, but just conducting yourselves as a judge would, essentially impartial, not having discussions with folks beforehand about the merits of the hearing, that kind of thing.
And no emails.
Discussions, emails, whatever.
Or phone calls, or?
And that is something to remember too. You can have a quorum digitally. So essentially, when staff emails you something, he's created the first leg of a quorum. So as soon as somebody responds back to reply all and saying, hey, this is what I think about that, you've created a quorum and have had an improper meeting under FOIA. Happens a lot, usually to no real detriment, except for me having to go out there and say, hey, don't do that. And I'm looked at as, the principal and bad guy and whatever. It's 23 years doing this, I've developed somewhat of a thick skin, but still, I hate doing it. So I'd rather y'all just, don't create a quorum unless you're having a meeting.
Could you give us some idea, what constitutes a conflict of interest since you're here?
In y'all's position, generally, all right, it's a narrow reading, but I would add some breadth to it. If you are gonna have some economic gain or loss in general terms,
That's,
by virtue of that decision,
That's obvious.
that, or a relative of yours is going to, that's when you have a direct conflict of interest. I would broaden that, the appearance of impropriety issues, or it's your neighborhood. Just things like this. I would tend to recuse myself if I was in that situation. You're probably not gonna have what someone could point out as to an economic loss or gain by virtue of your decision. If it's your neighborhood, it's a large Kiwi Key or whatever large neighborhood, you're not gonna be able to point to something. But just because someone said, this is in Kiwi Key, this is 2 blocks down from your house, and you're making a decision on this for the county, I mean, that's the kind of thing that sounds bad. And so it's good with a smell test on it sometimes for that appearance of impropriety. But
I don't think so, you're a customer of somebody's, or something like that, is that a?
generally not, because if it's the difference is going to, here's kind of the essence of the test. If the decision you make is going to have a special effect on you, then you've got a serious issue.
Okay.
So if the decision you make is going to have it may benefit you by some means. So a store is going to get situated that you like,
Yeah,
you know, on a
and they're
corner.
gonna expand.
But it's going to benefit everybody or have the same impact globally on a number of people, then you're not going to have that same kind of conflict. It's not there. That's the general rule as applied. But I would just, if you've got a gut check, and you've got a good gut.
I'm sorry?
I said, if you've got a gut check and saying it,
Oh, no,
you've got a good gut. I mean, you've got
I just wondered, just wondered how you came down on that.
that's just,
The thing that crossed my mind before I was on the board, I happened to be watching one of the sessions, and there was a variance for Yoders, for example. I said, gee, I'm a customer of Yoders, but I mean, I don't know the Yoders, but I do buy lumber from them and things like that if I have projects. I was just wondering to what extent, because it seemed to be a little bit, I think, a little stricter here than maybe in some other areas that I've lived in.
yeah, that'd be a general issue and wouldn't present a strict
I
comment.
just thought I'd ask just to be on the safe side, so.
It's a statute that's out there. It's pretty specific. If you have an economic gain or you're a relative, a near relative,
Yeah.
it's going to have an economic gain or suffer a loss by virtue of the decision, then you need to recuse yourself.
Thank you.
Mr. Root, I had a couple questions on some of your highlighted areas that I just for education, on page 33, on the third-party intervention, the first paragraph, you follow? And it
Yes, sir.
says, South Carolina provides that the motion to intervene must be granted if the person has substantial interest in the decision of the board. I guess I don't understand what that means.
It's the same as the ability to appeal. So if someone has appealed the decision, a third party who is not, who wasn't perhaps at the hearing or certainly wasn't the applicant or wasn't someone who presented evidence in opposition, a third party could intervene into the proceeding that's already going on in the circuit court and say, hey, this is my interest in this particular case, and so I want to be a party. I've got my own attorney or I don't, and I want to present evidence or not evidence, but I want to have argument in front of the circuit court on this appellant matter. So I'm intervening
Is it
into the
before
case.
the appeal is heard or after?
This is during the appeal to the circuit court. So it's already been appealed up. There's not a decision that's been rendered, and a person intervenes. But that same person, that's a standing issue. Do you have the right to do that? That same kind of standing quality is for someone who could appeal. So if it's, you're a neighbor, you're part of a homeowners association group that has an interest in this property. This property is within the homeowners association, so you appeal on behalf of the entity. You can do that because you have an interest. Your party and interests have a substantial interest, something that's definable.
Then on page 35, number 1, appeal to the circuit court, in the second sentence, it says, although the statutes do not require serving the petition on the board, it is advisable. I have no idea what that means.
Yeah, it's really a matter of, all right, so y'all have rendered your decision. Someone can take it off and run with it in objection by appeal to the circuit court. It's really a good idea to bring you all in, notify staff, you've got an appeal. You're going to find out about it, but what they're saying here is that it's not required that you have the written petition to the circuit court served contemporaneously on the board, but it's a good practice.
Gotcha. Okay. I guess that's it. Does anybody else have any questions on any of the documents?
I had one. Could I ask a question?
Sure.
Page 36, right at the top, standard review, the findings of fact by the board. I don't remember finding any facts. I'm just confused by the fact and the law. I mean, okay, I understand the law, but facts, what facts are we finding?
I guess the best way I can do it is by analogy with the traffic accident. So the judge, in any case, and you all being the judges, are going to have findings of fact and conclusions of law. You're going to apply the law to the facts and render your decision. The law is essentially safe for a variance are those criteria, and the facts are the situation of the property. and so this property is an odd property because of X, Y, Z, and it's situated differently than any other property in the county, and so applying this law, this zoning ordinance provision or whatever to this property works an unfairness. So that's the law is the ordinance. The facts is essentially how the property is situated.
Well, it's kind of still our opinion, though, of what the facts are.
Oh, it is, yeah. I mean,
It's still an
that's your
opinion.
finding. It's
Still
your
an
findings.
opinion then.
It is.
We'll call
And
it a
it's so,
fact.
yeah, going back to the traffic incident, so the judge is gonna find a finding of fact, say, all right, the car ran the red light. It's still up for dispute, obviously, because they're at the hearing, and you have many cases about this, who ran the red light, who didn't. The judge is gonna make, or the jury, if it's a jury trial, is gonna make a finding of fact that the car went through the intersection when the light was red. Then there's a law, all right, obviously, that would be against the law, disobeying a traffic signal, but then there could have been some intermediary law. Was there an emergency that excused this behavior? Was it a licensed emergency services vehicle, police, whatever? So you apply that law to the fact that he ran through the red light.
I'd have trouble with the facts are in the kind of cases.
In y'all's
we
case,
get involved in.
it can be a little bit different. They often do blend together. Yeah. So,
Okay, so that's what the term, okay, I understand.
You know, kind of as a follow-up, Jim, on page 66, the second paragraph in the middle, it says, most importantly, when questioning the applicant, the members should only ask questions or request information concerning facts that are available to the jurisdiction, established criteria governing the dispute. I know that since I've been on the board, there's been some board members that have asking all about their business and how's the business going and all kinds of information that, and I gather that's what this is saying, is that we need to just be asking questions that relate to the appeal that's being requested,
Absolutely.
rather than general business questions or things like that. And you probably have seen that too. Other people have kind of, are just interested in their
Yeah.
business and asking all kinds
and
of.
there could be any number of those, and that goes back to, was your decision based on some sort of discriminatory foundation? And if you're asking, is your sister still around?
Right.
You know, I don't like her. And so you're asking that question, it has nothing to do with the variance special exception, then the attorney is like, I've got a good basis to appeal when they decided that, based it on a relationship or whatever.
Some comment to the effect, for example, that you had, it's like we have a large group here tonight, because we have 55 folks who disagree with this, let's deny it.
Say that again, I didn't
Is
hear
that
what
your
you said.
rationale? It's just because there are 55 folks present who don't like it? That would be a concern.
I still didn't hear what you said.
I can't hear you.
He was just saying that because you've got, if y'all were to make a comment from the bench or from here, because you've got a large audience and several people are, raising their hands or making a big ruckus, that somebody says, well, obviously the public is against this, so we should probably deny this application, something like that. That would hurt.
That wouldn't be
Don't do
good.
that.
That'd be gross.
That would be bad.
Yeah, I just don't, it's not good to voice that.
Right. Right.
Mr. Rue, I have another question.
Yes, sir.
Should we be swearing in the people?
That's why I said I didn't come very often, because the last time I did come, I tried to make it formal and swear them in, and get a little bit more procedurally formal with the taking of evidence, et cetera. It doesn't always work. I think it's a good idea to swear in the witnesses. I'm not even say that in your rules,
I mean, you wouldn't have to do that, would you?
no, the chairman would do
I'm
it.
not sure if our rules say that.
So,
I don't believe they do.
I don't remember reading that in the procedures.
Yeah, I don't remember either seeing that.
Twenty
It's
county
not
board
a
of
statutory requirement, but I agree with David that it's a good idea.
Yeah.
so parties in interest may present testimony under oath.
So,
That's
may,
swear.
So that,
you certainly may do it.
I would move that we require the parties to swear an oath
As a motion,
as a motion.
is there a second? Is there a second?
He's making a main motion right now, so he's moving that the chairman take testimony under oath going forward.
Don't I need a second?
Yes.
Yeah, you need a second.
I don't,
Okay.
no second?
I think things are working okay.
That's right.
That's my, yeah. I mean, we've got the option to do that. If we,
Yeah.
I guess if you sense there's something coming up that's gonna be, a big deal, and you really wanna put people under oath, I guess you could do that as a one time for that particular hearing, couldn't you?
Could,
Yeah.
just always remember kind of that equal protection deal. Are you treating the same
Everybody
kind of
the
people
same.
the same way under the same circumstances? So you've got two hearings up here, you decide, don't like the looks of this guy, we're gonna put him under oath. Next person comes up, same
No,
kind of
you didn't know.
situation.
I think
You follow that procedure for the whole hearing. If you decide for that hearing, you're gonna put people under oath.
And the subsequent hearing, if you have the same nature of conflicts, the same nature of witnesses,
Okay, yeah.
whatever. I'm
So
just-
for that night,
just
you ought to deal.
treating the same people similarly situated the same way. And that's what you wanna do. Just so nobody feels like they've been singled out for some reason or another.
I think it's part of the process. I remember when that was recommended to us before, because we do on occasion let people talk from the audience, and not everybody always comes up to it just was administratively, it could be kind of cumbersome to try to do.
Just wondering if it would keep them more honest, that's all.
Oh, I don't know.
I haven't
think
seen that
people
to be
are-
an issue myself.
Okay.
They're gonna represent things the way they want. They're gonna
Yeah.
give their own opinions, and may or may not be right. That's part of our job, is to figure out what they're saying, whether we agree with
Yeah.
what they're saying, whether we agree or not. But I'm not sure. Again, I go back to trying to do what's right, and I don't think, in our particular cases,
We need that.
that would jeopardize doing what's right. That's where I'm at. That's why I didn't.
That's all right, that's
Does
fine.
anybody on the board have any
Just throwing it
questions
out.
of Mr.
Sure.
Root? And do you have any other items you want to cover with us?
No, that was it. I just wanted to address that one, and there's some information and material, and just to remind you all, like any other board,
Thank
if
you,
y'all
sir,
need me,
for
I'm
taking
glad-
your time to do all that. I know
I'm
it's a
glad
lot
to
of
do it.
preparation. I thank you for that. Thank you
Yeah,
very much.
definitely.
Helps
And
us.
you know, I think it helps us as a group is we're more aware of the rules and regulations. It helps us function better as a group,
Sure.
because
That's
we've
right.
had some of these discussions. So thank you.
Absolutely.
Okay, are there any old business?
I think, I'm not sure if it's under old business, but we have some information to give you just about some of the things that are going on.
We're having
Could you
trouble
speak
hearing
up?
you.
Could you speak up?
We can't hear you.
We can't hear you over
Really?
here.
Okay.
I really can't hear you, Bill.
Okay, what I was going to say is that we've got, it's not really old business other than to discuss briefly some of the ongoing projects we've got. And I can give you a little bit of that real quick, and that won't take but about a minute and a half
Okay,
to do, because it's getting fairly busy out there. And I think Jim kind of alluded to that earlier. And I'll show you something this is something Adam had put together just as a sheet that gives you the stats from January to August 15th of this year about the kinds of applications and permit information that's coming in. You'll see that residential reference there is 30 to 40 new home permits have been issued each month. On average, it's been 30 to 40 range since January. That's 238 new homes, stick-built homes, 98 manufactured homes set up, 82 remodels, 54 garages, 51 residential additions. Then on the commercial side, since January, 22 on new construction permits valued over $145 million. And then 21 remodels, that's all commercial, through August 15th. That's permits issued. This thing on recreational vehicles is through August 15th also, but it's just indicating something that's, the only way we really have a tracking RVs is that they've got electrical setups. So you see electrical permits, and when we see those grouped together, you kind of see what's going on. 100 plus electrical setups for RVs since January. A good bit of RV action out there. Major upcoming projects, another student housing project is coming into Hartwell Village. The full plans have not been submitted on that yet, but it is coming. It'll be, I believe, apartments. The
Actually, on
cliffs-
the Hartwell Village site,
Yes.
where they got the Hilton Hotel, they're gonna put
That's
apartments
correct.
in there somewhere.
They need some more apartments and trucks. They just need to put two big parking lots on each side.
Yeah.
Just park, walk through.
That's correct. And the cliffs expansion reference is that the cliffs that, as you know, you probably know, it's a very large area, partly developed. The developer currently is involved, is looking to expand, and they're doing it as expeditiously as they can by doing it in segments. So we've seen about 3 or 4 different plats for the cliffs that have come through the process here in the last month or two. One of those plats is about 40 lots. The others are somewhat smaller. But clearly they are in the process of trying to get these through and to sell a lot more of the parcels, the properties within the cliffs.
Bill, are they on the water or off the water?
They're almost all within the overlay. Some are.
But on the water
some
or
are on
off?
water, I don't know that they're all on water. But they're
It's all in Oconee County, it doesn't have anything to do with the cliffs over in Pickens.
No,
Doesn't have anything to do with the
I'm
other
talking
cliffs.
about- Not in Pickens, I'm talking about here. and
Just-
this is-
all right.
Yeah, all within the overlay. This thing referenced to Davis Creek, an Old Clemson Highway, as you probably noticed. There's a Bojangles going right directly across from the Ingalls there at 123 and Old Clemson Highway, that if you know where I'm speaking to somebody, know what I'm talking
You
about.
mean where the Roadrunner was?
Correct. Yes, sir.
Okay.
The Roadrunner was torn down, that's where the Bojangles is going. In addition, there is across, as you noticed, the construction going on next door to Ingalls, across Old Clemson Highway from it anyway, is a gun range,
Yes.
project. And, in that same area,
Yeah, fast, yeah, with the fast.
car dealership is also expanding.
Has he applied for the permits?
Yes, sir.
He's expanding, or is he gonna put his Ford dealership on?
I'm not sure. When did you know about what the deal is with that? I'm not sure what the plan is with that. I just know that they're building another building. So if it's part of the,
Moved a lot of cars across the road.
that's right, they have cars right now parked across the highway
I
from
mean,
the
they've got
current
cars.
site, so.
I
I don't really know the plan on
Wouldn't
that.
want to pay the floor planning on that.
Bill,
Excuse me.
what's the official word in terms of what they're building? Is that a Marriott Courtyard? The people say that's gonna be a Marriott Courtyard there on the lake, right on 123.
Oh,
in
that's in the
Seneca.
city of Seneca.
Right.
That's in city of
I
Seneca.
believe
But-
I believe it is a motel. I do not know any details because it's in the city.
Okay,
Seneca,
true,
and
true,
I haven't seen the plans on it.
okay.
More back out there at Davis Creek and Old Clemson, they're also building right next to the shopping center that has the grocery store in it. It's not an Ingles, it's something else.
Food line.
Food line, it's a food line. They're moving dirt there.
Right.
What's going in there?
Panera Bread.
Um,
I think Panera Bread's going in there.
I'm
Really?
not sure, that may be, I'm not.
It's a
certain.
separate-
There's a lot of dirt
That's what
being
my wife
moved.
says anyway.
Yeah, they have.
She's
they have.
happy
I
about
was
that.
involved in the site, review on that one, so I
Okay.
didn't take note of it that closely.
I think it's Panera Bread.
Is it?
I guess what it all points to is we're seeing a lot of activity, and that points to this issue of all the planning work that's being done now in terms of corridor studies. Are there things we need to be doing to address all the growth that's happening? And the timing's interesting, that we're in the middle of this planning process, so it's good timing.
We ought to plan for
And then-
growth.
Yeah, there you go. And at the bottom, it says non-subdivisions for 50-plus new homes, and that's referencing back to what I said, which is that we're seeing more plats being submitted than we have in a long time.
Has anything been submitted on the Thornburg property on 123 next to the golf course at Richland? Because they own all the property from Walmart to the golf course.
I do
And
not know.
Thornburg Children's Home inherited that, and
I don't know. I'll check.
Is it Thornburg
I haven't seen anything- I haven't
Children's
seen
Home
anything on
owns it? You know where that is? You know what they're talking about?
I know where the property is, I've seen.
Yeah, this is the kudzu patch.
Got an old barn on there, lots of good barn board.
It's something,
We can look it up, see if there's anything. I don't, that doesn't ring a bell.
But the price tag on it was 300 million. That's the reason I was asking.
300 million?
300 million?
That would ring a bell.
Close.
Yeah, jeez.
300 million,
Right there, 123.
Well, it's over 300 acres.
$1 million an acre for that property?
Yeah. It's got water, sewer, natural gas. It's perfect for plants. It's perfect for strip malls. I mean, that is a prime piece of property. I would love to see manufacturing go in there.
I'm with you on that. That's-
But that's all I have.
Okay. Any new business?
Oh, I will mention one other thing. We may have a meeting in November, because I had a discussion with an agent for, a company working on a cell phone, tower site, today, and that's, he probably will submit that for the November meeting.
No October meeting then? No October meeting?
I don't think if we get an application by Thursday of this week.
Almost
we will
too
have
late.
one, but so far I've heard of.
I can tell you,
Nothing that's
I
gonna
won't be
make that.
here in November if you're gonna do it on the fourth one, because we go to Florida every year for
I
November.
know that timing is not good, so we'll see what he does.
Tough life.
Okay, any other old business?
So that's it.
Any new business? Anybody like to make a motion to adjourn?
No, I'd like to discuss one thing. I'd like to move that, in the case of, when we're deciding a particular case, that, that we not allow it to die on not having a motion. That we, in every case, that we have a motion, and then we have a second, and then we have discussion, and then we vote on it either up or down, rather than allowing it to die right at the front end like we did with that.
Well, that's a valid option in Robert's Rules of Orders.
I know it is, but I'm saying from a policy standpoint, I think that it creates a little bit of a problem, I think, in perception with people, that we're really not voting on it.
We owe it to them to have some sort of discussion and some,
Yeah.
at least some result that they understand we considered it, and that we didn't just.
Case in point was the guy with the trailer. I mean, he was, really upset when he left here, but he left here feeling that we really didn't give him any consideration because we didn't vote on it. And we just let it die. And I agree with you. Robert's rules say that that's a legitimate way of doing it, but
I
I'm
was on
saying.
another subject. I thought you were talking about your motion that we didn't,
What?
it never went to second, so that's what I thought you were
Oh, I'm
talking
sorry.
about.
I'll
On a different subject.
I'll put that into a motion, that we, that when we're deciding a case, that we have a motion to accept, a second discussion, and then we vote on it, whether it's yes.
Was I here then? I don't remember.
We actually did that, John. We actually, there was a motion.
Yeah, I
There was
can't
a- there was a
imagine.
motion
Once
to-
we were open.
We went by
We did.
the four criteria, and we were on the first criteria,
Yeah.
and we said,
And we never got a second.
we never got a second on it, that's
And what
right.
I'm saying is that we, as a procedural thing, we give, somebody makes a second, we discuss it, then we vote on it,
Right.
yes or no.
And
Rather
we
than,
didn't do that.
rather than
I
allowing
can't-
it just to die.
Well, it did, Jeff, if I recall, it just died.
It
You know, there was
died.
really wasn't any discussion.
Yeah, it was just a pregnant pause.
That's kind of up to the chairman to handle
Yeah.
that, or really just.
I don't remember that, but yeah, that's the last thing in the world we want to have happen.
Yeah, it just, any way you want to handle it is fine, but it just bothered me that we let it die that way.
And was I chair at the time?
I'm not sure, I think you might not have been here.
I mean, I just don't
I'm
remember
not
that
sure, do you remember the
situation.
guy with the trailer? What
Someone
was his name?
the guy who wanted to move a trailer.
Trailer.
uh,
And he'd
over
already
on,
moved it into place?
I don't remember it, but,
Okay, you may not have been here.
but anyway, I think the point that you're making is that we owe it to anybody that has an appeal that we have
Yeah.
a final vote on that.
Yes or no?
Okay, yeah.
Yes or no, not
I certainly would
allow
agree.
it to die
I'm not
on
sure
Robert's
why
rules.
we wouldn't, but do you remember that at all?
Yeah.
Okay,
I remember him coming in I remember him getting mad.
Big
Yeah,
time.
I remember him
I know the case you're talking
He
about.
came, he
but I
came
wasn't here
unglued
that
them,
night.
which
Yeah,
was not right.
yeah, and it died for lack of a
Yeah.
second.
So, I mean, however,
I think that's something we ought to just keep in mind, as we
Keep
owe
in mind how you-
people some sort of
And
discussion.
we all owe it to ourselves, because obviously
Yeah.
so we all owe it to ourselves to make sure that doesn't happen. I
Yeah,
think, rather than-
and I was thinking in terms of.
Well, I
maybe-
guess the thinking there too is if somebody seconds it, if it dies for lack of a second, then that means nobody was gonna vote for it anyway.
Right,
Probably.
right.
Yeah.
So,
Right.
that-
What I'm saying-
Proper, I don't
what
think
I'm
there's any
saying-
proper way to.
What I'm suggesting is that that in a case like that, we second it for discussion and then vote unanimously if we want to decline it. But to give the person at least the vote on the thing.
Right, I
So that they
agree, but I'm
feel,
not sure that we would have a motion to do that, because that's really up to somebody to second
well,
it.
you make a motion and then what I'm saying, there's from a procedural standpoint, that I'm suggesting that we do that, even though it's not a strict interpretation of Robert's rules, suggesting that we as a board
I think I'm agreeing with you.
agree to.
I'm trying to agree with you.
Yeah.
Trying very hard.
I'm okay, I agree, but I'm suggesting we not do that as a motion, that we do that as a practice.
That's fine.
Yeah.
Fine, if that's
If that's okay
that's
with
acceptable to
the other board
that.
members.
Well, I guess the only question I'd have there is, okay, if you call for a second, and I say, okay, I'll second it.
Yeah.
Then what's the discussion gonna be if everybody's sitting there saying, you know,
Well,
if we're just doing that, I mean, is anybody gonna say anything? Or is it gonna be, well, okay, we have a motion and a second.
Well, then we
Any
call for a
discussion?
vote.
Right, or any discussion. If there's no discussion, we call for the vote and
Right.
everybody vote no.
Right,
Okay. I mean,
yeah.
I think a motion to accept whatever it is, accept
Yeah.
it, and a second
A
to
second.
accept it, does not necessarily mean you're in
gonna
favor
vote.
of it.
No.
You just want to get the
Yeah.
thing decided.
You want-
Right, right.
That's what I would recommend is.
Yeah,
that you-
I think that's a good way to go.
Yeah.
Procedurally, I think,
Whatever
Yeah.
your position is, someone needs to give a second on it, and then you can vote however you wish.
But I think we need to do that. Whatever the mechanism for doing it is.
And I think we're agreeing with you.
Yeah.
time to shut up.
As they say, when you're in a hole, stop digging.
Okay,
Move adjourn.
do I
Second.
have a motion to adjourn?
You got one. You got a
You get
second.
a second? All in favor, say aye. Aye. Adjourn. So is the